Welcome to UXL, where you can learn new skills anytime and anywhere. Visit uxl.com to explore our full course selection. This lesson is part of a larger course. Check the video description below for a link to the full course where you can enroll. If you enjoy our content, please like and subscribe. For your convenience, the course cover displayed on your screen provides the complete course title and lesson title. Let's proceed with the lesson. Lesson: Legal considerations for workplace monitoring. Workplace monitoring encompasses a range of activities that employers undertake to oversee employees' interactions and behaviors during work hours. These activities can include, but are not limited to, tracking emails, phone calls, internet usage, and even physical movements within the workplace. This practice has grown increasingly prevalent as technology continues to evolve, presenting both opportunities and challenges for employers and employees alike. Within the context of California law, the legal considerations for workplace monitoring are complex and multifaceted, requiring HR professionals to be well-versed in both federal and state regulations to ensure compliance and protect employee privacy. California's approach to workplace monitoring is distinctive due to its stringent privacy protections. The California Constitution explicitly recognizes the right to privacy, which extends to employees in the workplace. This constitutional right means that any form of monitoring must be carefully justified and balanced against employees' privacy rights. Employers must navigate this landscape with precision, ensuring that their monitoring practices are not only legally compliant but also ethically sound. One of the primary legal frameworks governing workplace monitoring in California is the California Invasion of Privacy Act. Enacted in 1967, CIPA makes it illegal to intentionally eavesdrop on or record confidential communications without the consent of all parties involved. This law applies to various forms of communication, including telephone calls and electronic communications. Employers must obtain explicit consent from employees before monitoring these types of communications. Failure to do so can result in significant legal repercussions, including civil penalties and potential damages. In addition to CIPA, the Electronic Communications Privacy Act of 1986 is a federal law that provides further protections. The ECPA prohibits the interception of electronic communications without consent, although it does contain exceptions such as the business extension exemption. This exemption allows employers to monitor communications if they can demonstrate that the monitoring is conducted in the ordinary course of business and that employees have been informed of such practices. However, even with this exemption, California's more stringent consent requirements under CIPA can impose additional obligations on employers. Employers in California must also consider the implications of the California Consumer Privacy Act, which came into effect in 2020. The CCPA grants California residents, including employees, specific rights regarding their personal information. While the CCPA primarily targets consumer data, its provisions can extend to employee data, especially if employers collect personal information for monitoring purposes. Under the CCPA, employees have the right to know what personal information is being collected, the purposes for which it is used, and with whom it is shared. Employers must provide transparent privacy notices and establish procedures for employees to exercise their rights, such as the right to access and delete personal information. Furthermore, the National Labor Relations Act provides protections for employees' rights to engage in concerted activities for mutual aid or protection. This includes the right to discuss working conditions and other employment-related issues. The National Labor Relations Board has issued rulings indicating that overly broad monitoring policies that infringe on these rights may be deemed unlawful. Employers must ensure that their monitoring practices do not interfere with employees' rights to communicate about workplace conditions, as doing so could result in unfair labor practice charges. The implications of these legal frameworks are significant for HR professionals seeking to implement workplace monitoring policies. To navigate these complexities, HR must adopt a proactive approach that incorporates several key principles. First, transparency is crucial. Employers should clearly communicate their monitoring policies to employees, outlining the types of monitoring conducted, the purposes for which data is collected, and the measures taken to protect employee privacy. This transparency helps build trust and ensures that employees are aware of their rights and responsibilities. Second, obtaining informed consent is essential. Employers should seek explicit consent from employees before initiating any monitoring practices. This consent should be documented and should cover the specific types of monitoring that will be conducted. Additionally, employers should provide employees with the option to opt out of certain types of monitoring, where feasible, to further respect their privacy preferences. Third, the principle of proportionality should guide monitoring practices. Employers should ensure that monitoring is conducted to the minimum extent necessary to achieve legitimate business objectives. Excessive or intrusive monitoring can not only violate legal standards, but also damage employee morale and trust. By adopting a proportional approach, employers can strike a balance between their business needs and employees' privacy rights. Fourth, data security is paramount. Employers must implement robust security measures to protect the data collected through monitoring. This includes encryption, access controls, and regular audits to ensure that data is not misused or accessed by unauthorized parties. Data breaches can have severe legal and reputational consequences, making data security a critical aspect of any monitoring policy. Finally, ongoing compliance and review are necessary to adapt to evolving legal and technological landscapes. Employers should regularly review their monitoring policies and practices to ensure they remain compliant with current laws and regulations. This includes staying informed about legislative changes and emerging best practices in workplace monitoring. By continuously evaluating and updating their policies, employers can mitigate legal risks and maintain a respectful and compliant work environment. To illustrate the practical application of these principles, consider a case where a California-based company implemented a comprehensive email monitoring policy. The company sought to monitor employee emails to prevent data breaches and ensure compliance with industry regulations. Before implementing the policy, the company conducted a thorough legal review to ensure compliance with CIPI, ECPA, and CCPA. They drafted a clear and detailed monitoring policy, which was communicated to all employees through multiple channels, including email, employee handbooks, and training sessions. The policy outlined the specific types of email monitoring, the purposes behind it, and the measures taken to protect employee data. The company obtained explicit consent from employees by requiring them to sign a consent form acknowledging their understanding and agreement to the monitoring policy. They also provided employees with the option to discuss any concerns or opt out of specific types of monitoring, where feasible. To ensure proportionality, the company limited email monitoring to work-related communications and implemented filters to exclude personal emails from monitoring. They also established strict access controls and encryption protocols to protect the monitored data. Regular audits and reviews of the monitoring policy were conducted to ensure ongoing compliance and address any emerging issues. This proactive and transparent approach not only ensured legal compliance, but also fostered a culture of trust and respect within the organization. In conclusion, the legal considerations for workplace monitoring in California require a careful and informed approach. Employers must navigate a complex web of federal and state regulations, balancing their business needs with employees' privacy rights. By adopting principles of transparency, informed consent, proportionality, data security, and ongoing compliance, employers can implement monitoring practices that are both legally compliant and ethically sound. HR professionals play a crucial role in this process, ensuring that workplace monitoring is conducted in a manner that respects employees' rights and fosters a positive work environment. This concludes the lesson. We trust you found this video informative and engaging. To enroll in the complete course, please use the link provided in the description below. At UExcel, we are committed to your learning journey. Each course offers a certificate of completion, online support, and downloadable resource files to enhance your experience. If you found our content valuable, we invite you to like this video and subscribe to our channel. Thank you for joining us, and we look forward to supporting your continued pursuit of knowledge.